Hi everyone, Michael Truman here with Munitions Law Group. Just wanted to do a quick video on a recent United States Supreme Court case, U.S. v. Rahimi. This just came out 6 days ago, so it's still relatively hot off the presses, and it is going to have a major impact on how Second Amendment challenges are looked at in the courts. So just to kind of lay the groundwork, what U.S. v. Rahimi was Rahimi was a citizen who was subject to a domestic violence protection order, and he was subsequently indicted and convicted for possessing guns while subject to a domestic violence protection order, which is in violation of federal law 18 U.S.C. 922 G8. He challenged that law, and it's worked its way all the way up to the Supreme Court, and the Supreme Court had to tell us, is it constitutional or unconstitutional to take away firearm rights for someone who is under a domestic violence protection order? The Supreme Court said that it is constitutional, and that it is constitutional to take away gun rights for people under a domestic violence protection order. The decision was 8-1. The decision was written by Justice Roberts. The lone dissent, as he frequently is, was Justice Thomas. And I'll talk about why that's interesting here in a minute. But the major implications of this are not necessarily in regard to domestic violence protection orders. It's broader in how Second Amendment cases are analyzed overall. So really, this was the first case post-Bruin to look at how Second Amendment challenges are going to be analyzed. And what Bruin was, a lot of our viewers are probably familiar with this, but I'll just touch on it. Bruin was a case in the Supreme Court 2 years ago where the Supreme Court struck down some New York state firearm regulations, and they laid down a new test for how all Second Amendment burdens are supposed to be analyzed to determine if they're constitutional or unconstitutional. Prior to Bruin, courts were basically doing an interest balancing, and under that interest balancing, almost every court was upholding the vast majority of restrictions on the Second Amendment under this interest balancing test. In Bruin, the Supreme Court said, no, that's not the right test. The right test is you have to look to the history and tradition of firearms regulation in the United States and see if the challenge law comports with that history and tradition. If it does comport with that history and tradition, it's constitutional. If it doesn't, it's unconstitutional. And again, the challenge laws in Bruin specifically, some New York state restrictions, they said that those laws did not comport with the history and tradition, and they were therefore thrown out. So here, this was the court's first chance to apply that test and shed some further light on it. And that was necessary because different courts of appeals were interpreting and applying Bruin in different ways. So in regards to how you apply this history and tradition test, what the court said in Rahimi is that a law comports with history and tradition in a general matter as long as it comports with basically almost, they said, the spirit of the law. There doesn't have to be what they called an exact twin dating back to the time when the Second Amendment was passed. So, for example, the way that the majority looked at it, they said, well, back in the 17th, 18th century, the time, when the Second Amendment was ratified, and then soon after, there was already firearm restrictions that took away rights for what were determined to be dangerous people or people who are likely to commit crimes with firearms. So the court said, well, that's similar to Rahimi, where Congress has found that people who are subject to domestic violence protection orders are likely to be dangerous with firearms, so we can take away their rights. So they said that that's a close enough analogy between the two. It fits in with the history and tradition of firearm regulation within the United States. The dissent would have required a much more specific match in the history and tradition. And it's interesting because, as I mentioned earlier, Justice Thomas is the one that wrote the dissent in this case, and he's actually the one that wrote the majority opinion in Bruin. So who better to know what Bruin said than Justice Thomas? But he was overruled 8-1 here. So the way that Justice Thomas looked at Rahimi, is he said, well, back in at the time the Second Amendment was enacted, there were no laws that disarmed people who were subject to domestic violence protection orders. I don't think domestic violence protection orders themselves were even a thing. So it doesn't comply with the history and tradition of gun regulation in the United States. And again, that's the narrow view that he looked at that test. The majority said, no, it doesn't have to be that narrow. We just have to kind of look to the general spirit of the law, and here this law comports with the history and tradition of disarming people. Again, I think that Justice Thomas's is probably the better reading of Bruin, but obviously 8-1, it is what it is. That's the way that the decision came out. So again, the implications of this now are all, there's been post Bruin, there've been a lot of challenges to firearm regulations across the country, and the district courts and United States Courts of Appeals have had to apply this Bruin test. Under this, I'd almost call it now a modified or a refined Bruin test. I think that, people challenging Second Amendment violations are going to have a much harder time winning their cases under this more updated Bruin analysis, where, just saying, well, back in the 16th and 17th centuries, we took away gun rights for people who were deemed dangerous. Rahami's deemed dangerous because he has a domestic violence protection order. That's enough. That's a lot easier than Justice Thomas's interpretation, where no, we have to have to comply with Bruin. You have to have a law, on the books back at the time of the Second Amendment was enacted that would have taken away gun rights for people in the same situation as Rahimi. And I'm not a family attorney that actually handles protection order cases, but from what I know about them, there's not due process. They're not the same type of protections for the person that's going to potentially be subject to the order like there is a criminal case. Justice Thomas said, and it's true, Rahimi, he had been accused of shooting at 5 different people, certainly not a model citizen, but he could have lost his gun rights if he was tried and convicted, by a jury, a judge, like anyone else. And if he was convicted of a qualifying offense, then he would have lost his gun rights. But he said, you can't take away his gun rights just for a domestic violence protection order because it doesn't qualify with the history and tradition of firearm regulation in this country. Again, that's not the way the case came out. So that's it on U.S. v. Rahimi. Again, these gun cases, they do not come before the Supreme Court particularly frequently. We had Heller in 2008, which first said that the Second Amendment right was a fundamental right enshrined in the Constitution. We had McDonald in 2010, which said that Heller basically applied to the states. And then we had no Second Amendment cases all the way up until 2022 when Bruin came down, and now we had this one here in 2024. So it's not very often that we have these cases, so they are, every basically gun case that comes in front of the Supreme Court is a big case. So that's it for that case. There is one more case. It's not specifically gun-related, but there's another case that I did a video on that's looking at the Chevron deference standard, and basically if that Chevron deference is something that allows government regulators like the ATF to have a lot of leeway in how they regulate in their specific area, and that decision is due either tomorrow or early next week, so I'll probably have another video on that. That's it for now. We'll have quick videos up if there's any further updates.